My name's David Taylor. I'm an accredited specialist in employment industrial law. I'm going to be speaking about adverse action, or the general protections provisions of the Fair Work Act. The adverse action provisions of the Fair Work Act provide a series of protections for workplace participants against what is defined in the Act as adverse action. The general protections provisions of the Fair Work Act arise when a person suffers adverse action because they exercise a workplace right. Workplace right is something such as making a complaint or inquiry about their employment. They exercise an industrial right. That's something like being a member of a trade union or taking protected industrial action, or because of a characteristic they possess, such as their race or their sex. Adverse action is defined very broadly in the Fair Work Act. It certainly includes the termination of employment, but it extends to not getting a job, so not being offered a position, being demoted, not being provided a bonus or a commission, or any other detriment that arises in employment. The general protection provisions don't just apply to employees, but also cover subcontractors. There are broadly two types of general protections claims. The first is one which involves the termination of employment, and the second is one that does not. A claim involving the termination of employment generally needs to be commenced within 21 days of the termination and should be commenced in the Fair Work Commission. Claims that don't involve the termination start in a court. For claims involving a termination, the process is quite similar to an unfair dismissal claim. An initial application is made, which is provided to the employer, and there is a reply filed by the employer. 4 to 6 weeks after the claim is filed, there is a conciliation conference, which generally, but not always, occurs over the telephone. At that conference, the parties get to put their respective positions, and there's an attempt to negotiate a settlement. In the event there is no settlement negotiated, the Commission will issue a certificate. The certificate entitles the applicant, so the worker who's been dismissed, to commence a claim in a court. At that point in time, the claim is quite similar to the general protections claim that didn't involve termination. The one important point is the certificate requires that the claim be commenced within 14 days of it being issued. There's very limited capacity for time to be extended. Once proceedings have been commenced in court, a normal court process is followed. There will be an exchange of pleadings, a formal document setting out the allegations each party is making, and then there'll be the preparation of evidence, generally in a written form, sworn as affidavits. Affidavits are sworn statements that can be tendered into evidence at the later hearing. Courts generally also require parties to attend compulsory mediation, which is often done before a court-appointed mediator. That's another attempt to try to settle the matter. If there's no settlement prior to the hearing, a judge will hear the matter, will consider the evidence, will consider legal arguments and any other documents that may be tendered in support of a case, and will make a final decision. In the event they find that there was unlawful adverse action, they will make an order as to remedies. The remedies can include reinstatement, commonly also include compensation for pain and suffering and for economic loss, and can also include an order for a penalty, which is a fine that can be imposed on a person who engaged in adverse action. It generally takes about 12 months from the commencement of a claim to the final hearing.